to this, your last class of business associations. Certainly not the way that we wanted to conclude. If you recollect, I took that picture of all of you at the very beginning during the first class, and it's usually traditional for me to take a picture for your very last class of Monday Night Law School. I know that's bittersweet not to be together in order to have that picture, and certainly the camaraderie and excitement that comes from the last week of law school. But make no mistake, with the circumstances as they are present in our world today, there's no greater need for good lawyers and good leaders than in this time. You were created, you were purposed for such a time as these. And so I am very optimistic that when you get finished with the final examinations in all of your classes and pass the bar exam, and you must and you will, then you are going to certainly go out and make a difference in bettering the world. And boy, do we need you now. That being said, we've got 3 cases that are left to brief tonight. Pretty easy material, not a lot of new stuff other than, I believe, the instrumentality rule, which is sometimes on the final exam and often on the bar exam. And then we will go into the review for the final examination. I'm going to hold my thoughts for the review on the final examination until we start that portion of the review, but I am going to go into great detail about what I'm expecting on the final examination, so make sure you are attentive. So let's do these 3 cases first. The first one introduces pretty much the only new law that we have for tonight. We've mentioned the instrumentality rule before, but this case not only introduces us to the terminology, but sets forth the legal criteria for the instrumentality rule. And that's the case of the estate of Mrs. Churchill v. Matthews. So this was a case of summary judgment, and in this estate case, the decedent, the estate actually, for the benefit of the decedent's estate and her heirs at law, is bringing a wrongful death claim against Defendant Baptist Memorial Hospital and Defendant Baptist Memorial Hospital Tipton, as well as against a doctor by the name of Barrett Matthews in this wrongful death case. Now, remember, when you have a dead person, there are certain things that you have to do in order for the dead person to sue, or quite frankly, if you are suing someone who is dead, then there's certain things that you have to do as well. There's statutory. I'm not going to test you over those procedures, but I want you to just hear me say it again and again, so that in the back of your mind, if you are involved in a case where the plaintiff or the defendant were to be dead, then you know you've got to go look for those laws in order to keep your case alive. And in this case, the estate is bringing the wrongful death case on behalf of the decedent. That's the easiest enough part. What becomes more confusing is when you want to sue a dead person. And what do you do if there's no estate open? And how do you get one open in order to sue a decedent, in order to perhaps get to the pools of insurance that might be available? What are the time restrictions involved? It's all statutory. So I'm going to say again, if you have a deceased person, or, and here's the tricky part, sometimes we may sue somebody, an alive person, and during the pendency of the lawsuit, the person dies. Well, you've got to do something there too in order to keep your lawsuit alive, and so that the lawsuit doesn't die with the defendant. Keep all that in your head. Make sure you just think to yourself once you're practicing, wait a minute, I think Miss Johnson said something about dead people. And if they die or are dead, then I have to follow statutory provisions, and you're going to search. So here the estate of the decedent, Miss Church, here brings the wrongful death action against the 3 defendants, and summary judgment was rendered as to one, Baptist Memorial Hospital, Inc. So the defendant's trying to get out of the lawsuit out of the get-go without even having a trial by saying there's no reason for them to have sued us. And as we know from civil procedure, or should know, that a summary judgment action is that defendant saying to the court, there's absolutely no material issue of controversial fact in play here, so that this should be dismissed as a matter of law. So what they are trying to say, this defendant, Baptist Memorial Hospital, Inc., in their summary judgment motion, is that we are a distinct entity. Yeah, we may sound similar, we may have similar names, but we are a completely distinct and separate corporation, and so therefore you can't get to us for something that perhaps another corporation did. The plaintiff is saying that one of these hospitals is the alter ego of the other, but they don't call it a parent subsidiary, which we've already covered, and that can happen, but they call it their sister corporation, that it's a horizontal, not a vertical relationship between the 2 corporate entities. And so they tried to put on some proof to demonstrate they're the same alter ego, but in refuting that, the affidavits of individuals who were involved with the moving defendant here stated that, yeah, while I serve on both boards, that's all I do. They are completely separate corporate structures as to BMH and BMH Tipton and Baptist Memorial Healthcare Systems, and they are separate entities. The same person may serve as president of all 3 of those corporate entities, and did so. They may have some of the same board members, but not all. I think one board had 9 and one board had 4, but they weren't identical in makeup. And neither of these alleged sister corporations had any ability to vote for the other. So they were claiming, for purposes of their summary judgment motion, get us out of this lawsuit. We are a total separate and distinct corporate entity. We have separate and distinct corporate charters, although the member or shareholder of each of the corporations was this Baptist Memorial Hospital Healthcare Systems, Inc. So you noticed how there's 2 corporations and the shareholders are a corporation. Remember, sometimes we have to chart this. A corporation can do anything that a person can do. They said these hospitals both operated under their own separate and distinct licensure and all of their own certificates. In fact, they went so far as to say the staffs were separate, the nursing staffs were separate, the doctors were separate. Even this Dr. Matthews, who, pursuant to perhaps a theory of respondeat superior as an employee, was getting his employer sued for whatever medical malpractice he may have committed causing the death of the decedent. It says that Dr. Matthews was never an agent, service, or employee of the movement to be dismissed pursuant to summary judgment, and had never been a member of the medical staff of that hospital. They had a registered nurse testify via affidavit. Similarly, they had other licensed medical doctors who worked there, physicians, do affidavits, sworn, testifying otherwise. These were not refuted. No counter affidavits were filed by the plaintiff. Now, they did point, the plaintiffs, to try to loop them in to a resolution that had a need to have cooperative arrangements, I think was the terminology used, for and among the area hospitals, specifically the one from Tipton. But just that agreement alone, which provided management, computer, and other administrative services for these hospital administratives, they were paid by 4% of BMH Tipton's gross patient service revenue, and it was charged on a monthly basis. Well, we are reminded that summary judgment is only granted when there is no material issue as to any genuine fact. It's kind of like when you move for a directed verdict at the end of all the proof before you put on your defense proof at all. Don't forget to do that. Sometimes you get lucky. In any event, it's undisputed that BMH Tipton was not acting as the agent of BMH in its care and treatment of the decedent. So it couldn't advance on that theory of respondeat superior, so they had to try to rely on the alter ego theory that these alleged sister corporations were one and the same corporation. So that's the theory here. And so there's law that talks about when one corporation actually controls another and operates both as a single system, the dominant corporation will be liable for injuries due to the negligence of the subsidiary. Well, that sounds like a parent subsidiary corporation and a vertical lineage, not horizontal. So what we know is this defendant's going to be dismissed because they were even calling it a sister corporation, and it was horizontal in structure, if anything at all. They just didn't share enough. But the reason this case is in your syllabus for tonight is because of its clear representation of what is called the instrumentality rule. The conditions under which the corporate entity will be disregarded vary according to the circumstances present in each case. We already know that. And a determination of whether or not a corporation is a mere instrumentality of an individual or parent corporation is a question of what? It's a question of fact for the jury. So we have to decide in this case, are there any disputed facts which would render this to go under the instrumentality rule? Well, here it said, wait a minute, this isn't even an instrumentality claim. In the case before us, it said, we do not have a situation where liability is sought against a parent corporation for acts of the subsidiary. Instead, the plaintiff itself, herself, the decedent's estate, uses the term sister corporation. So we're not even going to have to worry about that. For purposes of learning the law, what is that instrumentality rule for the parent and subsidiary, and what does it require? And so the requirements of the instrumentality rule are threefold in the case. Number one, the parent corporation at the time of the transaction complained has such control and dominion over the subsidiary, not only about the finances, but of policy and business practices in respect to the transaction under attack, that one can only naturally conclude that it's not a separate mind or entity. It doesn't have a separate will or existence of its own. That's the first thing you have to prove. And these are not ors, these are ands. You have to have proof of all three. Number two, such control must have been used to commit a fraud or a wrong, to perpetuate a violation of a statutory legal duty, or they're just dishonest or an unjust act in contravention of someone's rights. You got to have that. And then, of course, the third one should not surprise you. Whatever happened, that control and that breach of duty must be the proximate cause of the injury or unjust complaint of. And because of that, the trial court's dismissal of this defendant was affirmed at the Court of Appeals level. Next case is Tiger Enterprises, Inc. v. Earl Hampton. This is a short little case, and it's kind of a review of what we've already done, with perhaps just adding on to it and perhaps a reminder and review for our exam. In this case, the defendant was lost at the trial court level, and a personal judgment was rendered against the defendant. And of course, the defendant's coming forward and trying to use as a defense on the appeal to the Court of Appeals that he should not have been held personally liable because he was a shareholder. This was a corporate debt, and only the corporation should be held liable. Now, in this case, this shareholder defendant is indeed the sole shareholder. But as we've already learned, control alone, total control alone is not enough to pierce the corporate veil to get to the individual 100% shareholder. But in this case, the plaintiff, Tiger Enterprises, Inc., doing business is Tiger Oil Company, which is fine. We know there can be AKAs. They are suing Mr. Earl Hampton because they're saying that their deal, Tiger's deal, was with Mr. Hampton and not with the corporation. Mr. Hampton, conversely, is saying, whoa, it wasn't with me personally, it was with the corporation in which I was the president of. So Mr. Hampton asked Tiger if Tiger would supply him with gasoline, diesel fuel, and petroleum products, in which they agreed. And Mr. Hampton agreed to take those, and if you'll just please bill Cumberland Energy. Oh, what is in a name? Well, that might be a question from Shakespeare, but when it comes to corporate law, names are extremely important. Notice that Mr. Hampton didn't ask them to bill a corporation. He asked them to bill an entity called Cumberland Energy. Well, can a sole proprietor have an AKA? Sure. And so if Mr. Hampton is a sole proprietor, he could be doing business as Cumberland Energy. What the plaintiff says they didn't know was that Cumberland Energy, Inc. is a corporation. But it really wasn't a corporation at the time, because that corporation had been administratively dissolved because Mr. Hampton had not filed the correct report. Well, wait a minute. That causes just an administrative dissolution. And we've already learned, and we already covered, that what cures an administrative dissolution when you fail to file a report? Well, you just file whatever report is missing. The state reinstates you, and it is as if it had never been administratively dissolved. Mr. Hampton didn't even know until the case was filed that the corporation had even been dissolved. So that's kind of some good proof that he was sort of operating this as a sole proprietorship and not relying in any way on the entity or the umbrella, the shield of the corporation. Now, there's some facts that swing both ways. Mr. Hampton paid the bill that was invoiced to Cumberland Energy on checks, which were on checks at the top, checks of Cumberland Energy, Inc. Suddenly, Inc. is so very important, and we need to remember that. He says, but I was sending it and paying it with a corporate check. Is that enough? Well, it says here all the bills that were sent out were sent in the name of Cumberland Energy and not Cumberland Energy, Inc. And and that there was no documentation or agreement between Mr. Hampton and Tiger. They did everything on a handshake. I don't know if there was any statute of fraud claims there, because this was a lot of money, but certainly there's going to be unjust enrichment excused if they got the gasoline, if they got the diesel and didn't pay for it. And he's not saying that he didn't get it, and he's not saying that the corporation doesn't owe the money. He's just saying the corporation went belly up and sorry for your luck. And they're saying, we didn't do business with the corporation. We did business on a handshake with Mr. Hampton. And so this case really goes all the way back to where we first started for corporations cases, and wherein if you're doing business with a corporation, then the corporation's got to make sure that everything is done in the corporate name so that there's no confusion. And because that wasn't clear, and Mr. Hampton is the sole one who signed things, he signed the checks without putting a corporate capacity, his individual name. He shook a hand, he didn't say it was a corporate contract. He said send it to Cumberland Energy, and never said it was a corporation. Because of that, the court affirmed the trial court below and found in favor of the appellee plaintiff, saying, no, this was not a corporate contract. This was a contract directly from Tiger to the individual functioning as a sole proprietorship. That he had a corporation is irrelevant. He didn't use it. So we have to be careful. In contracts that we make, need things in writing, need to include the corporate name, need to sign things in our representative capacities, so we can't get sued in our personal capacities absent our own wrongdoing. Wow. We're at the final brief for business associations class. You know, since we've done this by audiovisual means, and we've had no snow days or timeout, this is actually the very first class that we've gotten through the entire syllabus with every case that's on the syllabus. Just sad that I didn't get to see you do it or hear you do it. You had to hear me. This is a very long case, this Delta v. Fannie Gulf International, but basically the whole case gives us a nice little review of the law regarding piercing the corporate veil. And in this case, we have two men, savvy businessmen, quite frankly, from Iran, who did close personal business together. A long time ago, they started the zoo over in Jolton, and it was bought out and then moved to Grassmere in Nashville, and so it involves some of those individuals. This case also involves discussions about a special master, which we've talked about now at great length. But in this case, there were lots of different corporations and lots of different shareholders, but the two primary ones that we're focused in on here are Farabors and Fannie. That's the best I got for you on pronunciation. And so in this particular case, there's a lot of money involved, and it is undisputed by anybody that this Fannie person, the plaintiff companies Delta, Zoo, Concession, and S&R, these companies were trying to figure out how much they owed on a loan. And that this Farbosi is the one kind of doing the filing because he feels like he's kind of being treated poorly. He had borrowed a lot of money from, I think, Fannie. I hope I don't have those reversed. I think I got it right. And he says that Fannie has been charging him usurious interest. And so he's not saying he didn't owe money. He's saying he's charging too much, but it's not him. Farbosi who is owing the debt. Farbosi says it's Delta, Zoo, Concession, and S&R who are entities that he represents and has shares in. And so the plaintiffs in this case are the corporations. And everybody agrees that money is owed. But the question becomes, what amount? And so this starts off as a very simple declaratory judgment action. The plaintiffs, corporate entities, admit they owe money, but not as much as the Fannie is saying that they owe, and they're only asking the court to determine, is the interest usurious and how much interest is really owed. Well, like I told you, sometimes when you get sued, the best defense is a good offense. So Fannie files a counter complaint alleging not only that all this interest is owed and more money than the other side admits, but that the corporation doesn't owe it, or these corporate entities don't owe it, or maybe they do, but also Ferdowsi is jointly and severally liable for his own wrongdoing because he actually took some of the corporate money and used it for personal expenses. I don't know if it ever said what they were, but there were large chunks of money provided to his son and to his daughter. So before we get anywhere, I just want you to know that the son and daughter maybe took the money, but they're not shareholders, so we can't really rope them in to anything. So he's saying we should pierce the veil to him for his own wrongdoing and hold him jointly and severally liable for the debts that everybody's agreeing these corporations owe. The question is how much and how much interest. So there was a lot of stuff going on, and it was a lot of dollar signs. So it's not surprising that the judge appointed a special master in order to hear those. And there came one report, and then they kind of accepted to it and brought some issues back before the special master until the special master finally settled in on a second report, which if they didn't accept from it after the court approved it, then one side is clearly appealed from the trial court's decision, and that, of course, is actually all of them. You know, when you go to the Court of Appeals, anybody can appeal anything they disagree with. So the first was whether the trial court erred in admitting a general ledger. I don't want to spend a lot of time on that. That's your evidence course in second year. I will tell you that I was taught by Mr. Lewis, who taught my evidence class at Nashville School of Law, just like the football coach that he was in his early years. We were all a little scared of him, but he was a dynamic teacher and extremely verbose in the way in which he expected us to participate and learn the laws of evidence. I don't know where you are on that class or how well you did. It's perhaps, as far as litigation, the most important class that I ever took. And so if you feel like you're weak in that area, not only for the bar exam, but certainly for purposes of litigation, I encourage you to purchase from Barbary or some other type service, Westlaw, whatever, audio tapes, audios for summations and learning evidence, not only for the bar exam, but because you're going to use it. And those of us who have a mastery of the evidence rules are actually doing so much better in the courtroom, and I credit Mr. Lewis for that, but you need to know it. As far as the general ledger in this case, the way it got in was perfectly acceptable, and so we won't focus anymore on that. But the other two issues were the primary issues that were important. So there are two issues in this case that we will discuss. Whether the trial court erred in not holding all third-party defendants individually liable. Isn't this a strange little twist of fate? The Forbose, where they pierced the veil and said, hey, you're going to be personally, jointly, and severally liable for all the reasons that we're going to talk about in just a moment. He's not upset that they did that, to be quite honest. He's just saying, if you're going to hold me personally liable as a shareholder and pierce the corporate veil, then you got to hold all the shareholders and owners liable for if you're piercing the corporate veil, not just me. Well, why would he take that position? If you remember when I told you about the facts, he took money from the corporation and he paid that to his non-shareholders, daughter and son. He really can't stand before the court and say he did do something wrong. So the only way he can limit his exposure is trying to get all the shareholders in cahoots with him by saying they knew and they didn't object, and they had every right to object, but they didn't. And therefore, if you're going to pierce the corporate veil and get to me, you got to spread the liability around and make them jointly and severally liable as well, not just me. And so that'll make his personal pocketbook take less of a hit. That's what he's doing here. So remember, sometimes what we argue in court may seem a little bizarre, but bizarre or not, if it helps our client and there's a good basis or legal theory on which to travel, it is our job to do it, as long as it passes the smell test and doesn't breach any rules of ethics. Don't forget the cases that we covered early on where lawyers actually got up in courtrooms and said, my client can't be held liable here because he's a drunk. Sometimes you're going to say negative things about your client in order to help them. In this case, he can't get around what he did. He's just saying they all did it with me, so they should be jointly and severally liable too. He also erroneously argues two case laws and he spins them, which is also our job if it is ethically okay to do, and in this case it was, because they were only cases he had to travel on, and said, hey, if it's piercing the corporate veil and I'm liable as a shareholder and an owner, here's two cases that say if you pierce the corporate veil, the owner is liable. I'm not the only owner, so they all have to be deemed jointly and severally liable too as those shareholders. But in this case, the Court of Appeals disagreed and said, no, the cases on which you rely were closely held corporations with only one shareholder that owned 100% of the shares. In your case, that's not the case. And by the way, Forbose, you're the wrongdoer. And those other individuals didn't do anything wrong, at least not enough to give rise to piercing the corporate veil against them individually. They just happen to be shareholders. So we're not going to say that if you pierce the corporate veil and get to one shareholder, that you automatically get to all of the shareholders who are relying upon the corporate shield of protection. In fact, in this case it says that in order to be personally liable, the shareholder must have done some misconduct on the part of the officer and director, and here only one of them did. Now he argues, Forbose did, that all the other shareholders acquiesced by signing some boilerplate language that actually approved anything Forbose did, but they said, no, we're not going to go that far and say just a blanket approval of what he does as the officer president of the corporation is enough to say that they had knowledge. In fact, they didn't have knowledge that he was literally stealing money for the corporation for his son and daughter. And so this piercing the corporate veil case is the reason that this case is on the syllabus. And in this case, unlike I think almost every one of the others, the court did pierce the corporate veil, and it was upheld on the piercing, but for it only pierced as to Farbozzi or Fairbourse, whatever his name is, and all the other shareholders were protected. This case gives us a lot of good laws about piercing the corporate veil. There is a presumption that a corporation is a distinct legal entity, wholly separate and apart from its shareholders, officers, directors, or affiliated corporations. But it can be proven, and usually that's by all of those Allen factors, I think 11 in all, Allen factors that we've covered ad nauseum, of the things that you look for or consider to ascertain if a corporate entity, the corporate shield, should be pierced to get to a shareholder. When a court is convinced that a corporate entity is a sham or a dummy or an alter ego, if you will, that they should disregard the separateness of the corporation, a court can pierce the corporate veil and attribute the actions of a corporation to its shareholders, plural. That's what he was arguing. But discarding the corporate entity must also have something to do with the misconduct on the part of the officers or directors. Who has the burden? Well, of course, the individual trying to pierce the corporate veil. Who was it in this case? Well, at first, it was the one who's owed the money, Feeney, whatever his name is, trying to pierce to get to Farbozzi. But once we get to the Court of Appeals level, it's now Farbozzi trying to pierce the own shield, because he didn't appeal that it should be pierced as to him, but trying to pierce it as it relates to his fellow shareholders. And of course, the way to do that is through the Allen factors. This case reminds us that it is extremely rare to pierce the corporate veil. It only happens in extreme circumstances, and a corporation's separate identity should be discarded, as this case says, with great caution. Farbozzi's personal liability was never appealed, and piercing the corporate veil was never appealed. What was appealed was Farbozzi saying, it should be pierced to all of us, not just me. But because the others had no misconduct, the court denied the piercing as to them. And then as it relates to the shareholders of the other corporation, it was an even weaker argument. He was saying, well, they forgave some notes, but that alone was not enough because they had good reason for what they did. Don't forget the business judgment rule, although not mentioned here in this, and they just didn't know of his direct misconduct. So, because the special master in this case carefully explained his accounting system and what it was for and why it was for, the Court of Appeals affirmed everything that the special master did and that the trial court found and entered. Whew, okay, so that gets us through the 3 cases. And now we're going to move into that part that I'm sure you are most interested in, and that is the final examination. Homework's looking good. The Allen factors are what I was looking for, obviously, in the little 2 essay where you chose or should have chose the one on piercing the corporate veil. We already know on your final exam it's going to be a derivative action suit essay question. I also am telling you, because of the manner in which we have had to conclude this class, and I had to come up with some way to ascertain you're watching these videos, and therefore did some homework along the way, your derivative action essay is going to be, you're going to be real happy with it. And so I'm taking the homework and kind of making it 5 points of the final exam. The derivative action essay will be 5 points of the final exam. And you know what I'm doing? I'm holding the final examination. I've already turned it in. I've already turned in my answer sheet. I've gone over it 50 million times and praying that we don't have any problems as we did on the midterm. I have not forgotten that you're going to have 6 points automatically onto the final examination to balance out those questions from the midterm. And so that's how that shows up in case something happens that you get 106 on the final examination and you got 100 on the midterm. You're not going to get a 103 class average. 100 is as high as it's going to go. But you know what I'm doing, and you know why I'm doing it based upon some error I made on the midterm. Don't think I'm going to have that on the final exam, but we'll pray about that. So there are, on the final examination, the format's going to be extremely similar to you. It's just longer because we have more time. There are 75 short multi-state questions. They are all multi-state, no fill in the blank. 75 of those, and they are going to be worth 1 point, 2 points each. When you get the final examination, it's going to say that the essay is worth 10 points. I'm reminding you again, the essay on the test will be 5 points, and 5 points will be based upon the homework you've turned in and uploaded. I need to know where to give credit, and so you need to have your name, that is your name, on every piece of homework that you have turned in. And you're going to upload that. I believe, and I thank those of you who emailed me and said, oh, I forgot to put my name on it. And so I went back, and I believe now I have opened it up that you can resubmit your homework and make sure that your name is on it. I can't tell by number. I can't tell by email. I have no idea. Some of you have some really crazy emails. I gotta have your name on the actual document, and I'm gonna open it up and look at it. Now, I'm gonna ask that you do me a favor. Some of you have said, or sent me a message or got word to me, what if I don't want to do the 5 points and I don't care about those 5 points, and by golly, just keep my 5 points. You have the right to do that. I don't understand why you would, but you have that right. What I do not want to do is delay turning in my grades because I am looking for your homework. So if you know that you're not going to do something, would you be so kind as to email me and just say, hey, this is Joe Smith, and here are the homework assignments I chose not to do. It's your choice. I'm fine with it. I'm just going to mark it off and I'm going to move on. But that will keep me from having to do as I did on the midterm, where some people chose not to do their take-home essay, which was shocking. But you have the right to do that, but would you let me know so the rest of the class isn't held up for weeks as I try to track you down or see, I'm afraid, what error I made. So, get all that loaded up, and the deadline for that is going to be for homework, because it's going to take me a while to grade all that. So this is your last class. So Monday, not tonight's class, but you've got 7 days to make sure it's all in, and then I'm going to turn off the ability to submit so that I can get the class participation portion and the 5-point portion of your final examination ready to go. So when you finish the exam on the 27th and get that turned in, I can grade it. All right. The 75 multi-choice are going to be worth 1.2 points each. I remind you that there may be answers that are true, false, or yes, no. Your answer sheet, if you're doing it manually in the office, you got to come there to do that. You need to be using A's and B's, not yes, no's, truth, false. I'll try to fix it if you're doing it manually, but you shouldn't have that problem. But if you're doing it on the computer, then obviously you won't have any issue. It'll be A, B, C, D, E, F, G. For the final examination, and I want to make sure you understand, you will not be required to know case names. But when I typed up the final exam, I just happened to have everything spread out as I was going through the syllabus. And so for some of the questions, not all of them, but some of them, I have written down the case name beside the question to try to help spark your recollection of what I am questioning over. And then, of course, the derivative action suit case is, or derivative action is the last question on the test. Now, I'm not going to go straight through this test. That would not be challenging enough for a fourth-year law class, but I am going to tell you, sort of like Dean Lozer, who is my dean for civil procedure, told me for a midterm, I'm telling you, study what I'm about to go over. I'm telling you, study what I'm about to go over. We've had a hard enough semester with everything going on, so trust me on this, all right? So let's play a little bit with some review, and let's see how good you do. So we're talking about corporations, reminding you that sometimes the agency law will come over and creep in as well. Or maybe the winding up laws. They just don't change. So, organization of a corporation, this is before a corporation is even formed. Who are the people that sign the charter and deliver the charter to the Secretary of State for filing? Who are they? Yes, the incorporators is correct. It would have been much more fun to have you answering these. Sorry for the format. So, can ABC Inc. serve as an incorporator for Speed Demons Car Rental Corporation? Let me repeat that. Can ABC Inc. serve as an incorporator for Speed Demons Car Rental Corporation? The answer is yes. Remember, an artificial entity can serve as an incorporator. In fact, that entity can do anything that a person can do. So it's only natural that a natural person could also serve as an incorporator. The corporate charter is a paper, a contract between the corporation and who? Well, the shareholders. It's also a corporation. It's also a contract between the corporation and the state of Tennessee. Now, there's certain mandatory requirements in the charter of what it must contain, which would include the name of the corporation, the number of shares that are authorized to be issued, and of course, if there's going to be more than one class of stock, then that has to be listed and what their respective rights are. Isn't it cool that these are the very notes that I gave you on the first night of corporations class, and I said, don't worry about what that means. You'll know by the time we get finished. And if you were listening through this semester, none of that language should have bothered you in any way now. Good job. You also have to have the street address and its initial registered office, and of course we want that registered agent for what? Service of process. We're going to put the name and address of each of the incorporators, the street address of its initial principal office, and we're going to have a statement of the corporation's purpose, that it is for profit And a lot of times that statement will say, engage in all lawful activity for profit. We need to know that because we need to know if we're dealing with a for-profit corporation. Obviously, if we're not, and we're dealing in the nonprofit statute, it's going to say that as well. Optional information that you may have in a charter would be the names and addresses of their directors, if there are any, when it is formed. There will be, but there may not be yet. If there's any exculpation clauses with the directors, which limits director liability for any breaches of duties, any provision that relates to the governance of the corporation, anything of that nature could be in there. Could I form a corporation with the name Bubba's Bountiful Biscuits? No. Remember, you got to have Inc., Co., Corp. to show its corporate status in order for that to be a corporation. You cannot indicate that an organization is for any purpose other than that which is in the charter. So that's why people sometimes write in the charter, engaged in all lawful activity. You want to distinguish it from the name of any existing corporation. And of course, as a lawyer, we just magically plug that in on the site of the Secretary of State's website of whatever they want their corporate name to be in order to reserve it, which you can reserve a corporate name for a fee or just go ahead and upstart it. But they want to do that before they start spending money on a corporate name that may already be taken. The specific statement of purpose, well, you don't really have to state a purpose at all. It's presumed to be a general lawful business to engage in all lawful activity, but if you do make a specific statement in your charter of what you're going to be doing, and you have something that you do that is outside that charter's purpose, what's it called? You're right, ultra-virus, U-L-T-R-A-V-I-R-E-S. So if the corporation does something that is ultra-virus, for example, if that Bubba's Bountiful Biscuits, Inc. I was telling you about has its charter to make and sell biscuits, and instead they later sell t-shirts, then we could argue that it is an ultra-virus activity. The consequences of an ultra-virus activity would be that the shareholders could sue to enjoin the selling of these t-shirts. We could make them stop the activity. Or two, the attorney general of the state could sue to dissolve the corporation. That's pretty rare. Or if the t-shirt activity loses money, the corporation could sue the directors who voted and permitted the ultra-virus activity. Remember, it's going to be the directors who participated in the wrongdoing. Those are the consequences of an ultra-virus act. Now, I ask you, is selling that t-shirt an ultra-virus act? And obviously, we could produce all kinds of facts to explore as to whether or not selling the t-shirt, did it touch and concern the business enough in order to perhaps advertise or sell these biscuits, and that becomes a question of fact as to whether or not it's ultra-virus. We've talked about certain definitions as we've waltzed through this corporations class. We know that authorized shares are the maximum number of shares that a corporation can sell. It's all it could possibly sell. We know that issued shares are the number of shares that are actually sold and outstanding by a corporation, which leads us to the definition of outstanding shares. the number of shares that a corporation has actually issued and not reacquired by the corporation for some statutory permissible reason, like right of redemption in a merger. Isn't it cool how I'm saying all this stuff and you know what it means now? Number of shares. The number of shares that are authorized for a corporation to sell needs to be stated in the charter. And if there's different types of stock, then those different classes need to be listed, and the different rights of those classes needs to be specified in the charter. The charter can provide for 2 or more different classes of stock, but they have to do it that way. Once a charter is filed for a corporation to spring into existence, it is going to spring into existence on the date of the filing, unless there is a different date stated in the charter, so for some date in the future. The charter is going to be delivered and filed with the Secretary of State, and the filing of that charter is conclusive proof against everyone but for the state of Tennessee that all the conditions have been met for corporateness to occur. Generally, the filing of the charter forms a de jure corporation. De jure meaning as a matter of law. Once the charter is filed, the corporation springs in existence. Perhaps there is an organizational meeting. It's not necessary for the corporation to spring into being, but obviously often there is an organizational meeting where directors are elected, if they're not already named in the charter, where officers are elected, where bylaws may be passed, and where stock is issued to shareholders. So we know that a corporation is a separate legal person, and that generally shareholders are not personally liable for the debts of a corporation. We're going to talk about the exceptions with piercing and things of that nature, or for their own individual torts, etc. We talked about whether or not in Tennessee there exists a de facto corporation. And in Tennessee, we had the case that said, no. If you don't meet the statutory criteria, we're not going to do a de facto corporation. There's just not one here. But corporation by estoppel can happen. And those two, remember we said they can be very confusing. To me, de facto corporation isn't confusing. There's just no one. But corporation by estoppel can be used when you as a corporate entity, or you think you're a corporate entity, have done a contract maybe to buy military ships, example in the big book that you didn't have to buy, and you spent $4 million to buy a ship, and then the entity that you paid the $4 million to isn't coughing up a ship. So the corporate entity sues to get the ship specific performance, and they defend and say, wait a minute, we just looked, and on the day that you entered in the contract, you weren't a corporation, so we're not going to give you a ship. Well, that's where corporation by estoppel comes into play. You can see how we almost have to have it, or they could take the $4 million and run and never give a ship. And so they can't turn around and defend against that. But there's no such thing as a de facto corporation. They couldn't say, hey, I got a ship. They couldn't say, you can't sue me as a shareholder because we didn't pay the $4 million because you thought you were dealing with a corporation. There's a good example. Yeah, they can. If they give the ship and they don't get the $4 million, then they can't say, well, we were a corporation if they weren't. And they can't say, well, you thought we were, to defend it. And they're going to get personal liability. And, you know, if they're not a corporation, then what are they? Where they're going to be a partnership or something to that effect, and all jointly and severally liable. Bylaws are not a condition precedent to the formation of a corporation, and bylaws are usually initially adopted either by the initial incorporators or the directors. Amendment of bylaws. Who can amend the bylaws of a corporation? Well, either the directors or the shareholders are able to do that, but when they are in conflict, it is the shareholders who generally control. We talked about pre-incorporation contracts and post-incorporation contracts, and so let's talk about promoter. We know that a promoter is an individual acting on behalf of a corporation before it is formed. He gets the financing together, tries to come up with office space, get the personnel lined up, all of those things. The person acting on behalf of the corporation before it is formed is the promoter. So let's talk about contracts which may involve a promoter, and what are those liabilities of the promoter. Let's talk about a pre-incorporation contract, which started us off on our case law in the corporation section. A corporation is not liable on a pre-incorporation contract until it does what? Not ratifies it, until it adopts it. Remember that fine line distinction between ratification and adoption that I told you, that even our Court of Appeals, Supreme Court will use those words interchangeably. But for purposes of exams and bar exams, if you are not a corporation, you can't ratify something that occurred before you were formed. You can only adopt something that occurred before you were formed. A non-existent person cannot be a party to a contract. A non-existent corporation cannot be a party to a contract. If the corporation adopts the contract, then the corporation is liable. The question most often on a bar exam question is not whether or not the corporation is liable on a pre-incorporation contract, because it's easy. Did they adopt it or not? The question usually is the promoter liable on the pre-incorporation contract? And generally, the promoter remains liable on a pre-incorporation contract until there has been a what? A novation, an agreement of the promoter, the corporation, and the other contracting parties that the corporation will replace the promoter with the corporation under the contract once the contract adopts it. Now, it doesn't mean the promoter has to be liable. We had cases where it said, well, it depends on the intent of the parties. If the intent of the parties that the promoter not be liable and only the corporation once it adopts it, then the promoter won't be liable. What's the intent of the parties, and was it clear? But quite frankly, why would you ever enter into a contract where you don't have somebody on the hook? So generally, the promoter remains liable, but it doesn't have to. And once the corporation adopts it, the promoter stays liable. If they were liable before, they're still liable once the corporation adopts it. Now they got two people on the hook, the person and the entity. And they will only remove the promoter once there is a novation. That novation can come after the corporation adopts, or it could be, and most likely always is, in the contract that says, in a novation clause, once the corporation adopts this contract, then the promoter is excused and relieved of liability. So how does a corporation adopt a pre-incorporation contract? Well, they expressly do it, they formally do it, they vote on it and do it. That's the easy way, and never the bar exam way. or they impliedly adopt it. You know, unjust enrichment. They start using the space. They accept the benefit. They do all of those things. The promoter has to be very careful about his actions in pre-incorporation contracts, in pre-incorporation circumstances, because the promoter has a fiduciary duty to the corporation. There is something called the secret profit rule. Since the promoter is a fiduciary, he cannot make a secret profit in his dealings with the corporation. And there are two distinct rules regarding that, and that's where dates become very important. So dates would only be on my test if the date distinction is imperative to answer the question. And so if you are a promoter and you do something, like you buy a piece of property before you become a promoter, and then you sell it to the corporation and you make a profit, that's okay. There's no secret profit rule. You didn't have a duty when you bought the property. But if you are already the promoter, you buy a piece of property yourself and then turn around and sell it as a profit to the corporation, all happening after you were the promoter, then any profit you make on that, you've got to disgorge, give to the corporation. Unless what? Well, unless the profit was known by the corporation, there's full disclosure, and everybody approved it, then there's no liability. So you have to distinguish on a test between whether or not it's a before or after acquired contract or circumstance that creates the profit for the promoter to determine if liability to the corporation is at issue. And then you have to look, is there anything in the fact pattern that would demonstrate that the corporation knew it, it was fully disclosed, and it was okay and approved. Absent those facts, then you're going to find liability for anything that the promoter personally profited for actions that he or she took after he or she became a promoter. Whew. We talked about the distinctions between a foreign and a domestic corporation. Foreign doesn't necessarily mean they're from a different country. It just means that it is a corporation formed and organized in a state other than Tennessee, but they are still practicing transacting business in the state of Tennessee. If it is a foreign corporation doing business in Tennessee, then that foreign corporation must qualify, register with the state of Tennessee. You know, I want to just say this briefly. If you're dealing with true foreign corporations, and by that I mean like foreign as in other countries, don't forget you may be dealing with the Hague Convention. It's tough. I've done maybe 2 cases with the Hague Convention total, one a personal injury case and one a family law case. Just put that in your little tickler, Hague Convention. If you're dealing outside the United States, you'll probably find that in play. All right. What is transacting business? When it says it is a foreign corporation is one chartered in another state transacting business within the state of Tennessee. Well, it's really not defined very well anywhere, but what we do have are exceptions of what is not transacting business. And that would just be like an isolated transaction. A continuum of business would be transacting business. When a foreign corporation is transacting business within the state of Tennessee and wants to qualify with the state of Tennessee, then they're going to simply fill out the document, the application that they can find on the website that requires certain information for them to qualify, and they're going to they're going to file it with the state of Tennessee, and we know that it is going to have the registered agent for service of process. What happens if a foreign corporation who is transacting business, a continuum of business inside of the state of Tennessee, is doing the business, but they are not properly qualifying with the state of Tennessee. Well, here are the consequences. They cannot prosecute a lawsuit until it cures the qualifying defect. So they can't bring an action, but it's simple. They're just going to go qualify, and then they can bring the action. And they are subject to a dollar penalty up to treble damages of taxes, etc., that they would have had to pay. But quite frankly, it's pretty lax. The contracts of a foreign corporation transacting business in the state of Tennessee without qualifying are valid. They're not void. They're not voidable. They're valid. We talked about issuance of stock, and that, of course, we know is when a corporation sells or trades its own stock. You know, if ABC Corporation sells 10,000 shares of stock to Biff, then that is issuance. But if I sell $10,000 of my personal stock to Biff, that is not issuance. The distinction is the corporation selling or trading its own stock. That's the definition of issuance. We also have some more dates here to kind of play with pre-incorporation and post-incorporation stock subscriptions. And these subscriptions are written offers to buy stock from a corporation. The big one that's hard to grasp is pre-incorporation stock subscriptions. And on these, it's when a corporation is not yet formed, ergo pre-incorporation stock subscription. And let's say that I do, excuse you certainly want this for purposes of your final exam and your exit from law school. So we'll talk a little bit about the voting on amendments to the charter in just a moment. Cumulative voting is only used when we are voting for directors. And cumulative voting is when a person has cumulative voting rights for purposes of voting for directors. And it's when your number of shares that you possess, the number of voting shares that you have, can be, if you so choose, multiplied by the number of directors to be elected, which kind of gives you more voting power to make sure you get the one person that you want in the directorship chair in. Let's do an example. Let's say that you own 1,000 shares of C Corporation stock, and C Corporation has 9 directors, all of whom are up for election. We got 9 seats available. You believe that Mr. Ross should be the director of C Corporation, and if you have 1,000 shares under cumulative voting, how many times or how many votes could you possibly submit for Mr. Ross? Well, the answer is 9,000. So you can see how that gives you a lot more power to get your guy in. Tennessee has an opt-in approach to cumulative voting. The charter's got to provide for it. It's not automatic. There is a right of all shareholders to inspect the books of a corporation, and these rights of inspecting the books are generally divided into 2 areas: general access and a special showing. General access is, I'm a shareholder and I get to see it. Boom. And that would include things like the charter, bylaws, minutes of the shareholder meetings, names and addresses of officers and directors, and the most recent annual report filed with the Secretary of State. You're entitled to inspect and even copy those. All you have to do is give written notice 5 days in advance to inspect and copy those, and any shareholder gets that general access of those real normal documents. More tricky, and in some of the cases that we studied, are the access or special showings, and that's where you want to see more detailed things, the money, get into the line item gritty of it. And so in order to do a special showing, you have to demand in good faith for a proper purpose, an ownership interest. Proper purpose can kind of be where we have those cases that argue that. You are going to describe in particularity the records that you want to see, and the records that you are demanding to see must be connected with the proper purpose. So proper purpose has got to be alleged. Here are the records I want to see with particularity, and those records clearly must relate to your proper purpose. We did the handout on dividend distributions. I just asked you to go back over those notes that we talked about. There'll be a few questions on the test about that. Homework looked really fine. Doesn't look to be too confusing there. When we have fundamental corporate changes, those are a little trickier. Remember that we talked a great deal about mergers, and when there's a merger, that provides the shareholder with their right of redemption to demand the fair market value of their shares of stock. And sometimes we get in controversy as to what that fair market value is. That's when we have competing experts, and we look at what we don't have to use it, but most likely and oftentimes is utilizing the Delaware block method. Remember, I told you about the case to remember Blassingame, so you want to review that case anytime you start to interview or deal with an expert, so you'll know how to communicate with your expert. But Delaware block method is often used to value the stock when somebody does the rights of redemption after a merger. That can also happen when the directors sell all or substantially all of the assets of the corporation, which kind of prevent its usual course of business, or when they start to have different new issuance and different kinds of stock or share exchanges. Sometimes it can be even an amendment of a corporation charter that would trigger a right of redemption, like preference or like a preference stock that we talked about. Suddenly we've got preferential stock, and you can see how somebody has a different kind of stock wouldn't like that. So that right of redemption might trigger, but the one we studied the most was merger. The shareholder, in order to trigger the right of redemption, is going to file a written objection to what's going to happen. They got to abstain and vote against it. They can't vote for the merger and then do the right of redemption. And then again, after it is voted in, they've got to demand in writing to be bought out. There are exceptions to that. If there's 750 shareholders or more, then that's not going to happen. And obviously, we don't need to value stock that's already on the National Stock Exchange. It's going to be in the paper. You just open it up and see what you get when you sell it. If you have amendment of the articles, this is another place that we vote that's a little different from the voting we said before. So the board of directors approval of an amendment to the articles occurs, and you're going to recommend that to the shareholders to amend the charter. So how many have to vote for an amendment to the charter? That's big, right? So the shareholder approval, the majority has to approve it that are entitled to vote. You see how that was different than a quorum? Let me give you an example so you'll get it. If there are 3,000 outstanding shares entitled to vote, how many must vote for the amendment? 1,501. Quorum be darned, you need 1,501 votes. What if only 2,400 shares vote and the other abstain? How many is required? Well, 1,501. Quorum be darned, you need 1,501, the same. And then once the amendment passes, it's going to be filed with the Secretary of State. Then we deal with dissolution of corporations, which brings us to the end of business associations as you know it. Sometimes a dissolution is voluntary. It's either by board approval or approval of the majority of the shares entitled to vote, but let me tell you how boring those are for a test. Involuntary judicial dissolution is the most likely one on the bar exam, and that may occur by a creditor's petition when they're not getting paid. Maybe the corporation is insolvent and there's a judgment a creditor has, it's going unsatisfied, so the creditor could petition the court. That's one way. The shareholders could petition. Maybe there's two shareholders, a deadlock 50-50, we covered those. There's a 50-50 deadlock with irreparable injury to the corporation. We covered some cases that resulted in judicial dissolution. Perhaps there is a shareholder deadlock, 500 shares, plus the failure to elect directors for the past 2 years. Those usually in those closely held corporations kind of are the same, to be honest. Or maybe directors are acting illegally, oppressively, or fraudulently, resulting in the need for a judicial dissolution, or corporations' assets are being misapplied or wasted. I think that's kind of the same as the other. And then, of course, we wind it up, and we wind it up by paying off the people or entities in the same order that we did before. My goodness, that brings us to the end of business associations. This is the last time that I will see you. We will not have another class, and I will not see you take the final examination, but I will be grading it. The next time I see you, I hope it is in the hallway as you are sporting your cap and gown and hood, ready to walk across the stage and receive your diploma from Nashville School of Law. I'm proud to have taught you. I'm proud of the discussions that you gave me in class. I'm proud of your work. I'm proud of your ability to persevere in these difficult times with your studies, with the fear and anxiety of your jobs and your family. But I'm telling you what, we make it through this, that's going to make you a better lawyer, a stronger person, and someone who will have incredible empathy, sympathy, and understanding to suffering clients. Until I see you again, study hard, and the next time I see you, I hope we're through all of this and we're all smiling and celebrating together. I'll see you, class, at graduation. God bless.